Hello, everyone. Welcome to a free Florida Bar approved CLE, significant fourth DCA case law developments from the fourth quarter of 2020. I'm going to be going over a PDF that I've sent in the chat function. I may have to keep resending it when people arrive. You should have it in the chat function. If you don't, just send a chat. But I want to get going because it's from 12 to 1 and I don't want to keep anybody longer. This is, I'm on the screen here. There's a reference number where you get your free 1 credit hour. And if you need a certificate from me or something for like work purposes or a different bar, let me know. But this number here is fine to go into floridabar.org and get credit for this. This CLE is on Zoom and it is being recorded. So just want to let you know that it's being recorded and will be rebroadcasted. It's a CLE being conducted by me, Colin O'Brien, and my company, the Florida DCA Wizard. And it's a for-profit company that provides real-time case law updates of Florida DCA decisions. For this CLE, I looked at all the decisions in the fourth DCA between September 2nd, 2020 and December 16th, 2020, Wednesday. And just in the fourth DCA alone, there were over 130 opinions, just in the fourth DCA alone. I'm not talking about PCAs, I'm talking about like actual opinions. I went through them all. It's what I do for the Florida DCA Wizard. And I picked out 38 cases that I thought were significant. I tried to go to different subject areas, so there's a little bit for everyone to enjoy. And as we go through this demonstrative aid, each of the cases have hyperlinks in them, so you can read the case on your own. Obviously, cases are complicated, they're long, there's a lot in them. So I'm picking out snippets of the cases that I think are significant, and I'm grouping them in the way that I think, but you can read the case. And I'm not addressing every issue in every case, but these are things that popped out at me. So the first set of cases are procedural due process. The reason why I picked these cases because in the other DCAs, there's a lot of due process issues I just have seen this year. So the first case I'd like to talk about is the Iriarte case with Judge Frink, the Aguilera case with Judge Green, the Riggs case with Judge Gunderson, and the Miller case with Judge Phillips. These are trial court judges, not the appellate court judge. And if you're seeing this rebroadcasted and you want a copy of the PDF, just email wizard@floridadcawizard.com and I'll send you a copy of it. The Iriarte case was about a sua sponte summary judgment hearing. The Aguilera case was about sua sponte sanctions after voluntary dismissal. The Riggs case was about whether courts have to provide hearings for motions for reconsideration. And the Miller case was about abusive pro se litigants and what can courts do. So the Iriarte case, Judge Frink, who's on the Zoom call, there was a sua sponte summary judgment hearing. And what happened in that case is that prior to that hearing, the non-moving party for summary judgment said, hey, I have an affidavit here, Judge, you can't grant summary judgment because I have an affidavit and it rebuts, it creates disputed issues of fact, so you have to deny summary judgment. So the court denied summary judgment based on the affidavit. Then it later came out that the affidavit was fraudulent. So there was a hearing on the motion to strike the affidavit. And if you look at the fourth DCA's opinion, I pulled out some quotes here on the screen of the transcript. It's super uncomfortable to read because the lead attorney who was supposed to, account for this affidavit wasn't there. And there's a colloquy with the court saying, the lead attorney wasn't here. We were told he was in trial. We called the judge he was supposedly in trial with, and he wasn't in trial with that judge. Oh, I meant, he's preparing for trial. So it's super uncomfortable. But Judge Frink did the logical thing, which said, well, if we're going to strike this affidavit and the affidavit was the only thing stopping summary judgment, why don't we just go ahead and enter summary judgment? Because you guys held me up on summary judgment based on an affidavit that's fraudulent. So now that we're getting rid of the affidavit, summary judgment makes sense to me. The fourth DCA said, no, you have to give notice of a summary judgment hearing. You can't change the type of hearing it is to a different hearing without notice. However, the fourth DCA had Judge Franks back significantly. They wrote here, I'm quoting from the bottom from the case, "We three former circuit court judges, having experienced similarly frustrating, if not unprofessional lawyering as the circuit court experienced here, fully understands the circuit court's actions. Frankly, if we had been in the circuit court's position, we may have done the same thing. But due process, you got to give notice of a hearing." So if you take what happened in Ariate and you look across the DCAs, there's a lot of this going on. I'm going to run through some of these cases. This is just the tip of the iceberg because, like I said, there's a lot, and the DCAs seem to be taking this sua sponte stuff very seriously. Judge Green's case in Brower, the Aguilera case, the fourth DCA reaffirmed the point that once there is a voluntary dismissal, the trial court can't sua sponte issue sanctions. Now, in that case, if you read it, the party actually got sanctioned for doing stuff after that. But in any event, no sua sponte sanctions after voluntary dismissal. The Energy Smart case out of the third DCA, Judge Miller in Miami, this was a sua sponte order striking a stipulation for substitution of counsel as a sham. There's a lack of prosecution hearing, and then this stipulation of substitution of counsel came in, and at the lack of prosecution hearing, the judge said, "You know what, I'm just striking this substitution of counsel." And the third DCA said, "Nope, you were on a hearing on the lack of prosecution. You were not on a hearing. You were not on a hearing on whether to strike the stipulation for substitution of counsel. Due process requires a notice of that." The Alvarez case, the third DCA, Judge Sanchez Lorenz, there you had a divorce case, and the court sua sponte issued a stay away order, and then sua sponte granted temporary and exclusive use of a marital home. None of that was noticed for hearing, and the third DCA said, "No, you can't do that." And there's a great quote from that case that says, "The granting of relief which is not sought by the notice of hearing or which expands the scope of a hearing and decides matters not noticed for hearing violates due process." It's a thing. In practice, it's very difficult to enforce that because you don't want to look unreasonable to the judge. You don't want to look like you're holding up the proceedings. Well, can't we just address this issue now? But the DCAs seem to be saying, no, it has to be in the notice of hearing. And you have the right to say, no, I need notice. Another case, Bank of Mellon versus Hernandez, a Judge Miller case again. There was a sua sponte dismissal of a claim without notice or hearing, violated due process. And the fifth DCA, another case I saw on this same topic, Wardell versus Fifth Third. This is Judge Falvey out of Citrus County. There was, I'm sorry, I'm just sharing a demonstrative aid for the people who are joining. If you are joining and we're already into this, look at the chat function. You should have the demonstrative aid. In the Wardell case, it was interesting. There was a summary judgment hearing. And then, as what happens a lot of times, people are like, oh, I have more stuff to say. And the person moving for summary judgment submitted all this extra stuff. And the court didn't give the non-moving party the chance to respond to the extra stuff. And the fifth DCA said, no, you can't, and then granted summary judgment. And the fifth DCA said, no, you can't have a summary judgment hearing, have new evidence after the summary judgment hearing, and not give the other side the ability to be heard. And then finally, the first DCA, Weston versus Weston. This is a little odd, probably not going to see this much, but the husband was in jail, and it was a final divorce hearing held with the husband in jail. And the first DCA said, you got to give that guy a chance to get on the phone or something for this final divorce proceeding. So this is just the tip of the iceberg, but I saw a ton of DCA opinions regarding sua sponte issues. Reminded me of the Ariate case, and I'm going to move to the next case. Riggs versus U.S. Bank. This is a Judge Gunderson case out of Broward. This stands for the proposition that trial courts do not have to provide hearings on motions for reconsideration. A party got a ruling they didn't like, and they filed a motion for reconsideration, and Judge Gunderson denied it without a hearing, and they took a writ to the fourth DCA, said, I want my hearing on my motion for reconsideration. And the fourth DCA said, no, you don't get that. The reason why I find this to be significant is because oftentimes litigating, there's a discovery order or some kind of order, and there's a motion for reconsideration that's filed that can hold up things. This case, I believe, stands for a very good proposition that you can say to the judge, not only should you deny it on the merits, we don't even have to have a hearing, deny it on the papers, and let's move on with whatever discovery order it is. Another case, this is Judge Phillips out of Broward County, Miller versus Henderson Machine. This was a pro se litigant. I'm sure we've all seen it. It was a little overzealous and started crossing the line. The pro se litigant tried to subpoena a court reporter, engaged in escalating and threatening conduct. The fourth DCA didn't really explain what was going on with that, but in any event, Judge Phillips said, "I've had enough. You need to get a lawyer. We can't have you doing what you're doing, abusing the process." And the fourth DCA said, "Yeah, that's fine. Pro se litigants get some leeway, but once you start subpoenaing court reporters and doing threatening stuff, that's it." This reminded me of a case. It's a good reminder to have decorum in court. The third DCA case, Judge Schlesinger in Miami. The third DCA upheld a 180-day sentence for direct criminal contempt during a hearing when, now, mind you, it was a criminal case, but in any event, the person said in open court, "So fuck me, basically, your courtroom's unfair." The third DCA said, "Yeah, you can give somebody 180 days in jail for that." So, okay, so those are the due process cases, Iriarte, Aguilera, Riggs, Miller. And again, for those of you who are joined a little bit late, this CLE just covers DCA opinions between September 2nd and December 16th, 2 days ago. There were over 130 written opinions, not PCAs, but like actual written opinions. I picked out 38 of them, and I'm just going to different practice areas, and hopefully something in there is helpful to you or is insightful. Every single case has a hyperlink so you can read the case for yourself. There's more to the cases than what I'm saying, but I'm just picking out the significant aspects for me. Okay, so on to some contracts cases. You have Triton Stone, Judge Phillips. You have Cooper case, Judge Hames. The Frankel case, that's Judge McNicholas. And Abdo, it's Judge Lopane. The Triton Stone case, Judge Phillips, these people wanted to restructure a company, and you hear about back of the napkin agreements. This is literally a back of the napkin agreement. These people met at a Dunkin' Donuts on several days to like restructure a company, and it was handwritten. The problem was it was super complicated, and there was an operating agreement, and the handwritten agreement didn't really take into account the transfer of membership interest and some other complicated things. And so someone tried to enforce the handwritten agreement, and the fourth DCA said, no, agreements to agree are not enforceable as a matter of law under Florida law. At most, the parties constructed an agreement to agree that was to be formalized in an appropriate manner as prescribed by the operating agreement. Excuse me, the takeaway for me in this case is, while it's good to get people, when they're ready to settle or negotiate, get them into a room and try to get it done, I guess it's pretty obvious. Once you have something super complicated, you really have to account for all the contingencies, because you can't just say, yeah, we're going to do this and do that if you don't account for it all. So complicated stuff requires a complicated agreement. You can't just do a back of the napkins at a Dunkin' Donuts to try to restructure a company. Sounds funny, but that's almost literally what happened. The Cooper case, Cooper versus Rehabilitation Center case, Judge Hames case out of Broward. This is a nursing home case. Nursing home lost power, bad stuff happened. So the nursing home got sued, and they invoked an arbitration agreement. And the fourth DCA said, yeah, that arbitration agreement is broad enough to cover what happened. And the arbitration agreement said, any controversy or claim arising out of or relating to this agreement or breach thereof. So the takeaway for me is, if you want an arbitration agreement to apply, make it super broad. There are a couple other examples that this case reminded me of. In the first DCA, this is Bailey versus Women's Pelvic Health. This is Judge Bransington out of Alachua County. there was an employee agreement between a doctor and a healthcare provider. Then the healthcare provider got sued about some like bad billing practices and wanted to say to the doctor, hey, you need to, help us out with this. And so like countersued the doctor and wanted to go to arbitration about it. And the doctor said, we're not going to arbitration. And the first DCA said, yeah, you are. Your employee arbitration agreement, even though it didn't say billing practices, it says any controversy or claim arising out of or relating to the agreement. So you're stuck with arbitration. So broad arbitration provision. This reminded me, of a case where the people sort of fell flat on their trying to enforce an arbitration provision. It's the Harvey versus Life Space Communities case, 5th DCA, Judge Soto out of Seminole County. It's a little convoluted, but basically these people had a residency agreement in 1993 to live at a community living center. They died, and then then the trustee came in to try to like market and sell their residency passes. And there was like a 2018 remarketing agreement. The trustee didn't like the way it was remarketed and sued. And the living center said, no, we have to go to arbitration. Back in 1993, the people who died signed an arbitration agreement in the residency agreement. And the 5th DCA said, no, that doesn't work. Your 2018 agreement didn't mention arbitration, and your 2018 agreement didn't mention the 1993 agreement. So you can't just osmosis in an arbitration clause. It's got to be in there explicitly. So takeaway for me is word it broadly, make sure if you're referring to another document, make sure it's specific. Okay, next case. The Frankel versus Costa case. This is an oral marital settlement agreement. Apparently, there are 2 rules for enforcing an oral marital settlement agreement. First, you've got to have people assent to it on the record. The second, the judge has to confirm that each party, again, an oral marital settlement agreement, each party discuss the agreement with their attorney and fully understands what's going on. Here, the judge, instead of doing the second prong on the record, said, well, I looked over at counsel table and I saw them talking to their attorneys during this whole discussion. So I figured they were talking to their attorneys about this oral marital settlement agreement. And because they were nodding their heads, I figured they understood what was going on. And the 4th DCA said, no, you can't take judicial notice of what you thought they were talking about. You need it on the record, oral marital settlement agreement. You have to confirm on the record that they discussed it with their attorney and understand it. Just a case that reminded me of this case, Thomas versus Thomas, 1st DCA case, Judge Register out of Bay County. There was a settlement offer for a divorce, and the person said, and the lawyer on the other side said, yeah, we accept, but also we need some alimony and some resolution of other stuff. And the person who added those extra terms tried to enforce the initial offer, and the 1st DCA said, no, you can't enforce the initial offer because you didn't actually accept it. If you're going to accept an offer, it has to be a mirror image of the offer in all material respects, or else it'll be considered a counteroffer that rejects the original offer. So you can't say, yeah, we agree, and give us the house and the cars and stuff. You have to make it exact for an acceptance to be enforceable. Those are, again, in the marital space, but I think that would apply in any, the Thomas case would apply in any space. Okay, next case, we have Abdo versus Avatar Property and Casualty Insurance Company, Judge Lopane case out of Broward. This is for you people who do insurance. This may have a lot of significance to you. There was a bad faith case, and the insurer won on summary judgment because the insured failed to attend the examination under oath. But the 4th DCA said, well, hold on, he didn't attend the examination under oath, but he said that his attorney didn't tell him about it, and then he went out of town. So apparently the attorney who was representing this insured withdrew from the case during the negotiations with the insurer prior to the lawsuit. And this was at a time when the insured went out of town. So the 4th DCA said, you can have this sort of excuse for an examination under oath, although the attorney, if it's true, did not tell the insured about the examination under oath, the attorney may get in pretty big trouble. But in any event, examinations under oath, if you ever deal with those, this some interesting language on how to get out of them because it's not per se. Okay, some written notice cases. There is the Julian case, Judge Robinson out of Broward. The Bay case, again, Judge Robinson out of Broward. The De La Riva case, Judge Perlman out of Broward. The Lakeview loan case, Judge Leday out of Broward. And here we go. So the Julian case, this was a bad faith action that was dismissed with prejudice because the civil remedy notice to the insurer, and I'm quoting from the case, listed nearly all policy sections and cited 35 statutory provisions. Like, hey, we're putting you on notice that you've done everything possible wrong for all time ever, every statute, everything. And the fourth DCA said, no, that's not going to work. You've got to be super specific. And if you're not, that's a defective civil remedy notice and you're going to lose. So that's interesting to me. You have to really know what you're talking about. You can't do a form notice to someone, not saying these lawyers did a form notice, but theoretically, if you just had a form sitting there on your desk, you got to curb it to exactly what's going on in the particular case. So that was in September of this year. And then like the next month, about a month later, Judge Robinson had another case that the fourth DCA reviewed about a civil remedy notice. This is Bay versus United Services Company, and is United Services Automobile Association. And the civil remedy notice there had the wrong insurance company. And Judge Robinson said, yeah, it's dismissed. Your civil remedy notice was defective. It named the wrong insurance company. But there, the fourth DCA said, no, that one we're going to keep alive because although it said the wrong insurance company, it was up to the insurance company who received the civil remedy notice to say something about that at the time in responding to the, and because they didn't make an issue of it, they waived it. Thus, I'm quoting from the opinion, thus the insurer waived the civil remedy notice's failure to properly identify the insurer. So a little juxtaposition about a month apart, same judge, civil remedy notice cases. The De La Riva versus State Farm case, Judge Perlman out of Broward. It's a little complicated, but it's the point is, if you're going to do a proposal for settlement, you got to make sure there's a served party in the case that's in the case. What happened here is there was a lawsuit that was filed and served, no problem with that. But then the defendant died. And then an amended complaint was filed before a representative came in, and the amended complaint just said John Doe. And so while that amended complaint was going on, those lawyers looked over to what was going on in the estate case in a different county, and they saw a curator of the estate, and they said, oh, okay, well, we'll serve the curator of the estate, even though we haven't named them as a representative, and even though we don't know whether they're going to be a representative in this case, with the proposal for settlement. Then another complaint, the complaint was amended and named an actual representative, not the curator. And then at the end of the case, they wanted to enforce the proposal for settlement and won. And the fourth DCA said, wait. You didn't do that right. You didn't serve your proposal for settlement on the actual person in the case. And there's like plain language of the rule. You have to wait 90 days after service of process before serving a proposal for settlement. And I thought this was interesting, not that you see many people dying during cases, but it's a good lesson to just hold on and make sure you have service on someone who's going to be in the case. The fourth DCA said proper procedure required the abatement of the proceedings until such time as a personal representative of the estate could be, and actually had been, substituted as party defendant and served with a complaint. So that, you went too quick, you needed to slow down. So that's that case. Lakeview loan servicing case, foreclosure type thing, but I put this in the notice category because the issue there was whether that green certified mail card was necessary to to be introduced to show that the certified mail was sent. Did you need that actual green card? And the fourth DCA said, no, you don't need the actual green card because there was somebody who testified that they sent the certified mail and identified a tracking number. So I don't know if this applies outside of foreclosure cases, but I could see it, an issue like that coming out in another context, and just like a general civil matter if someone did or did not send a green card and what do you need to do to prove it. This seems like a pretty good case. This case threw me for a loop because if you read the concurring opinion in the Lakeview loan servicing case, Judge Gross had some very strong language about another case called PennyMac that was decided about a month before Lakeview loan servicing. And I pointed out here because you don't see language like this too often, at least I didn't this year in reviewing the DCA opinions from all the DCAs. Judge Gross said, because PennyMac floats like a virus in the legal ether, like a virus in the legal ether. One of the unwritten rules of judging is to do no harm to settled law. Strong, strong language. Apparently, this PennyMac case, according to Judge Gross, confuses who has the burden. Is it like the borrower to show that service hadn't been made, or is it the HUD to show that service had been made? And that really changes the evidence. And actually, I found an example of that happening in the first DCA, Russell versus Wells Fargo. Judge sued out of Duval County. I think this is exactly what Judge Gross was talking about. So the burden was on the homeowner to show that this conditions precedent were not met because the homeowner did it through an affirmative defense. And it was his, the homeowner's burden to prove the affirmative defense. So they lost. So heavy language by Judge Gross, but I think he has a point. The burden really matters. But anyway, notice, do you need a green card? You can have testimony that says the green card was sent, the certified mail green card was sent. And if you identify a tracking number, you may be good. Okay. Some trial issues, cases, Tumblin versus State, Judge Levin out of St. Lucie, Moltrop versus Geico, Judge Rowe out of Palm Beach, RJ Reynolds, Judge Rodriguez out of Broward, Sears versus State, Judge Shepard out of Palm Beach, Thurston versus State, Judge Colruyt out of Broward. Tumblin versus State, it's sort of a non-controversial point that it was okay to have the victim in the courtroom because there's a statute that says victims can be present unless there's prejudice shown, and there was no prejudice shown. But what jumped out to me about this case was an apparently unequivocal statement by the fourth DCA that the rule of sequestration does not apply to opening statements as opening statements are not evidence. So the rule of sequestration is what you invoke to get witnesses out of a court proceeding. But here, this was unequivocal that that rule does not apply to opening statements. Very interesting. So that was just very interesting to me. Moltrop versus Geico, Judge Rowe out of Palm Beach. This is a bad faith case that was overturned on appeal. The court allowed the insurance company to tell the jury about the settlement discussions. I quote some of the language here, but this was like a closing argument by the insurance company about the settlement discussions. 50,000, and they go to mediation, and 50,000 again. Now they want 500,000. That's what this is about. Look at what they did in mediation. And the trial court allowed it, and the fourth DCA said, can't do that. First of all, it's not relevant, which I guess that is obvious. And then there's something called a settlement privilege and a mediation privilege, and you violated like a lot of bad things. So sorry, we had to overturn this trial. So don't talk about mediation. This is an example of it being used in a closing argument and it reversing a trial. RJ Reynolds versus Kaplan. This is Judge Rodriguez out of Broward. It's a tobacco case. There's a lot going on in the case. So the thing I'm picking out was that the plaintiff's counsel compared the tobacco companies to the Nazis. And the fourth DCA said, you can't do that. You can't use inflammatory improper arguments. They must, strong language, must be stopped to maintain public confidence in our system of justice. To me, a quote like this, if you had difficult proceedings with the other side or the litigants, this would justify a pretty strong motion in limine that some of the things that were said in deposition or heated things should not go in at trial because inflammatory arguments must be stopped. I think it's pretty good fodder for a motion in limine. Another case along those lines that I saw, Bugs versus State, 5th DCA case, Judge Kest out of Orange County. The prosecutor should not have said the following, I'm quoting it, talk about illusions, smoke screens, distractions, things that aren't relevant, because throughout opening statement and the questions of witnesses, there were a number of allusions made by the defense. The 5th DCA said, no, you can't talk like that about the other side. So potential fodder for motions in limine. Thurston versus State, Judge Kalra out of Broward. Here, a mistrial was not warranted, and the prosecutor said, when the jury was out, but apparently in front of the defendant, the defense needs to go back to law school because literally impeaching a witness was first year 101. I'm sorry, I know the law. And it wasn't a mistrial because the defendant remained silent, so it wasn't clear whether the defendant heard it or not. But what was significant, again, along the lines of what the 4th DCA said in the Kaplan case, in this case, they said comments that disparage the integrity of counsel are improper and highly inappropriate. We remind and caution all attorneys that they are held to a standard of conduct and have an obligation to uphold the integrity of the justice system. So again, this would be fodder, in my opinion, for motions in limine. If you have a difficult opposing counsel or difficult witnesses, they're going to say something that's outside the bounds. This seems like good law to say, Judge, please don't allow them to say that at trial. What happened in the Thurston case reminded me of what happened this 5th DCA case I had seen, Willis versus State, Judge Kest out of Orange County. It came up in a concurring opinion, and it came up in an ineffective assistance of counsel analysis. But anyway, what jumped out to me is that the lawyer was wearing bedroom slippers during trial and ate cookies or crackers in the presence of the jury, picking up crumbs from the counsel table, called her client a jerk in closing argument, and threatened to leave during the trial. And the 5th DCA said, rude behavior and unprofessional conduct have no place in a court of law and contravene the precepts of professionalism expected of members of the Florida bar. So fodder for motions in limine. Okay, another trial case, Sears versus State, Judge Shepard out of Palm Beach. This, again, if you guys are joining a little late, it's no problem, but I'm just picking out parts of cases that I think are significant. You can read the case and there may be other things going on in the case. And there were, just to recap, there were over 130 written opinions in the 4th DCA, just the 4th DCA, between September 2nd and December 16th, not PCA, like actual written opinions. And I am going through 38 of them. So I'm on to this case here about juror. Okay, Sears versus State, Judge Shepard. The 4th DCA said the trial court was justified in excusing a juror for being evasive in response to the question, can you be fair? So I have the colloquy on the screen that the 4th DCA put in the opinion. I'm reading from the column all the way on the rightmost column. This is like the $1 million question, so to speak. Ma'am, this is the judge to the juror. Ma'am, I have one question, yes or no? If you were selected to be a juror in this case, would you be fair and impartial? The juror says, emotionally, I'm not good. I can't even watch the news anymore because I get very frustrated on everything that's going on. So based on your experience, do you think you could be fair? Like I say, I used to love to be here. I used to be very proud to be here, but not anymore. Okay, thank you. So that was enough to get the juror kicked off. What I thought was interesting, and you can read it for yourself, was the stuff that the juror said before that about her views on society. But in any event, seems like a good repertoire to have about that question if you want to rehabilitate a witness in response to that question, or if you elicit questions regarding can you be fair, this is a good roadmap on how to deal with that. Discovery and evidence cases. We have Walker, Judge Kaplan out of Broward, State versus Torres, Judge Garcia Wood out of Broward, CNN versus Black, Judge Curley out of Palm Beach, Rodriguez versus State, Judge Timothy Bailey out of Broward. Walker versus Harley Anderson, Judge Kaplan out of Broward. There was a stalking injunction, and the 4th DCA said you shouldn't have, to the judge, you shouldn't have introduced these text messages because they were not sufficiently authenticated. And in the case, there were like 10 pages of messages, and the person seeking the injunction said, I know it was from him. I know it because the content of the messages, I know that those were sent by this person I'm seeking an injunction against. And Judge Kaplan, I think, did the logical thing and said, I don't know who else would have done that. And given the relationship, it was probably that person. And the 4th DCA said, no, that doesn't work. There's no direct evidence that the messages were sent. No one saw or heard the appellant send the messages, and so on and so forth. In this analysis, there's a great string cite of cases where text messages have been allowed, haven't been allowed. It's like a very exhaustive list. It's super helpful if you have a text message and you want to try to get it in through a motion of limine or something. Pages 2 and 3 of this Walker versus Harley Anderson case. So that's fine. Okay, you got to authenticate text messages. But then, like about a month later, in State versus Torres, in Judge Garcia Wood's case out of Broward, the 4th DCA said, no, you shouldn't have excluded the messages. You should have, no, they were authentic. And the 4th DCA said, yeah, we knew that the defendant sent them because the victim thought that the defendant sent them. Based on his extensive history of texting and the content of the messages and so on and so forth. And I have a hard time reconciling the analysis in State versus Torres with the analysis in Walker versus Harley Anderson, because what the 4th DCA did in State versus Torres seems a lot like what Judge Kaplan did in Walker versus Harley Anderson. Granted, serious charges in State versus Torres, but in any event, text message was authenticated apparently. So those are 2 good text message authentication cases. Next case, CNN versus Black. This is Judge Curley out of Palm Beach. There were some emails and text messages between CNN and its co-defendant in a defamation action, and the court said, yeah, we get to get those messages. There's no journalist privilege. There were some defamatory statements made by CNN regarding infant mortality rates, and the doctor sued CNN. And the 4th DCA said, well, the only way that this doctor is going to establish defamation is he needs to see what CNN was looking at before they published the story. So when weighed against the possibility that the plaintiff stands to lose his day in court and be denied access to courts, and the privilege, we're going to say the privilege goes away. So that's an interesting journalist privilege case. Text messages and emails, mind you, in a different context. Okay. Rodriguez versus State. It's Judge Timothy Bailey out of Broward County. Defendant crashed his car. He was rushed to the hospital, and the state said, yeah, okay, reckless driving, crashed his car. We're going to want all the records from the paramedics in the hospital. We want to see what was in his blood and his urine and all that. And the 4th DCA said, nope. No, wait a second. Just because he crashed a car doesn't mean he had anything in his system. And I'm quoting from the opinion, we disagree that every reckless driving incident creates a compelling state interest to obtain toxicology records. There must be some reasonable founded suspicion that alcohol or drugs were involved, such as someone is smelling alcohol, drug, or alcohol containers, and so on and so forth. You just have a bare suspicion, you don't get the hospital records. I thought this was interesting. This could apply, I think, in civil cases as well. Okay, next case, or next series of cases, motions to suppress cases. We have EM versus State, Judge Kastronakis out of Palm Beach, State versus Daly, Judge Garcia Wood out of Broward, RF versus State, Judge Ross out of Broward, Tedford versus State, Judge Hazy out of Okeechobee. EM versus State, there was an interview by the detective at the defendant's cousin's house, and apparently Miranda was not required because it was not a custodial interrogation. because it was at the kitchen table and the person's family was around. This is a hard one for me to understand. The motion to suppress should not have been granted according to the 4th DCA. But if you look at what the detective was saying to the defendant, I just have a hard time understanding this, but maybe I should read it again. I'm not here to arrest you, or I'm just here to take your statement, just talk to you. And the defendant says, like, right away, am I going to be provided a lawyer? Are you going to be, you're going to come to the station and it's voluntary. You're not under arrest. This is your opportunity to give your side. We can talk here. But like I said, am I allowed to be provided with a lawyer? You could have retained an attorney all the time. Of course you could have, but why would you need an attorney? Don't you need to explain what happened? This is your opportunity, because you're not going to get another opportunity. And you know what a lawyer is going to do? He's going to tell you to be quiet. I don't know, not a custodial interrogation. Miranda was not required. Interesting case. State versus Daly. This is Judge Garcia Wood out of Broward. Judge Garcia Wood granted a motion to suppress based on a be on the lookout that was overbroad and not particularized. And the 4th DCA said, no, black male, 5'11", wearing a gray hooded sweatshirt is sufficient to justify the stop. Interesting case. Something else that was interesting about it is the 4th DCA was okay with the bicycle light violation as being grounds to stop. They said, we are not persuaded by the argument that the officers lacked reasonable suspicion to stop defendant, either based on be on the lookout or the bicycle light violation. So the bicycle light violation, enough to justify a stop. Judge Gross, again, in this case, had some very strong language about the majority opinion and dissented, and you can read it, but very strong language. Contrary to the law, the majority has reweighed the evidence. Some changes in the law are momentous, see Brown versus Board of Education. Others, as in this case, come into the law like Carl Sandburg's fog on little cat feet. I think he was saying Judge Garcia Wood already weighed everything and made the right decision, and it's not for the 4th DCA to like overturn it, but we did, and that's not what the law says. It's a very passionate dissent. This reminded me of a case I saw in the 2nd DCA earlier this year, Judge Kaiser versus Hillsborough, Judge Kaiser out of Hillsborough County, regarding this bicycle light violation. There was a broken taillight on a car, and that was not sufficient to justify a stop. Yes, it was 8:45 a.m., but broken taillight on a car, not sufficient for a stop. In the 2nd DCA and the 4th DCA, bicycle light, yeah, we can stop you. Broken taillight, no, can't stop you in the 2nd DCA. Bicycle light, 4th DCA, can't stop you. Interesting comparison. The next case, RF versus State, Judge Ross out of Broward. This is a flashlight case. There were some people parked in a car, and a detective, a police officer pulls up next to them, shines a light, and you can see the analysis here, but that was not a search. It did not violate the 4th Amendment to have a spotlight and shine in the car. So that's an interesting case. A lot of analysis there. There may be some fact-specific issues that would change it for other cases, but shining a light in a car in a parking lot, yeah, you don't have a reasonable expectation of privacy to do with what's going on in your car if you can see it through a flashlight, according to this case. Tedford versus State. This is Judge Hazy out of Okeechobee County. This is a drug dog sniff case, and the 4th DCA said what they were dealing with was an issue of first impression. A lot of words here. I'll just read them, but I think it's more simple than what the words say. But we address an issue of first impression, the propriety of using a drug dog to sniff the passenger of a vehicle during a traffic stop based on a reasonable and articulable suspicion the passenger possesses drugs, where the sniff itself is not based on a warrant or probable cause. 4th DCA said, yeah, that's good. You can do that. So drug dog sniff case, pretty significant. I suspect there will be further stuff going on in other DCAs, and probably the Florida Supreme Court will take this issue up, if not the US Supreme Court. Okay, some property rights cases. Habal versus Habal, Judge Spicer out of Broward. Goldberg, Judge Hames out of Broward. Brandt, Judge Waters out of Martin County. Danforth, Judge Lopane out of Broward. Davino, Judge Bowman out of Broward. And Gabrigi, Judge Phillips out of Broward. Habal versus Habal is a revocable trust. The dad remarried, and then like the trust gets changed, and the son doesn't like it and sues the trustee for tortious interference. And the fourth DCA said, son, you do not have standing challenge a change to the trust because you're not the guardian and your dad's still alive. This is a contingent remainderman issue. Excuse me. The fourth DCA said a contingent remainderman who is not the settler's guardian does not have standing to challenge the viability of an amendment to a revocable trust while the settler still lives. Your dad remarried. You don't like what happened to the trust. Sorry, he's still alive. Can't do anything about it. Next case, Goldberg versus Universal Property and Casualty Insurance Company. This is an insurance case. For those of you who deal with insurance issues, there was damage to the house and then the personal property, not including the house. And the insurance claim to the personal property, to the house was dismissed because the insured, the homeowner, did not abide by the insurance contract. That was just a bar to the action. You didn't comply with the insurance contract and you can't then recover for what happened in the house. However, the fourth DCA said not complying with the insurance contract was not a bar to recovering for the personal property because the insurance company, Universal, failed to pay any amount for personal property losses and denied coverage, and such a denial waives the insurer's right to insist upon the insured's compliance with policy conditions. So covered for the house, not covered for the house, covered for the personal property, and the insured did not follow the insurance contract for both things. But because the insurer denied coverage for the personal property completely, they can't insist that the insured comply with the policy. There's some in the weeds insurance stuff in there, but if you do insurance cases, I'd look at that one. Brandt versus MetLife. This is a lawsuit to stop a Martin County court from being the venue for a foreclosure on a mortgage encumbering real property in Okeechobee. I'm quoting from the opinion. The borrowers obtained 4 separate loans from the lenders secured by real property described in 4 separate mortgages. 3 of the mortgages encumbered real property in Martin County. 1 of the mortgages encumbered real property in Okeechobee County. Which county? Cross-collateralized mortgage issue. Which county? There's a state statute right on point. It says when a mortgage includes lands lying in 2 or more counties, it may be foreclosed in any of said counties. Interesting. So Martin County was okay. But the fourth DCA said, in a footnote at the end of the case, said, we're letting you know that because Okeechobee and Martin are both in the 19th Judicial Circuit, this impacts our analysis. So may have been a different result if it was counties outside of the same judicial circuit or maybe outside of the same DCA. So foreclosure, mortgages, cross-collateralized mortgage issues. Danford versus Jamaica Bay East. This is a Fair Housing Act case. Judge Lopane out of Broward. The trial court granted summary judgment in favor of the landlord who tried to evict a family with an autistic son. The autistic son's car was towed, and he reacted one day banging loudly on the door and swore and allegedly threatened people. And the fourth DCA said, hold on, can't just evict somebody because their autistic son has a bad day. Let's look at whether we had any reasonable accommodations and, whether notice of a disability and request for accommodation were given. So I thought it was an interesting Fair Housing Act case. Lots in there. Next case, Davino versus 2436 East Las Olas. This is an easement case over private property. So 2 private individuals signed a document for an easement, and they signed it back in 1948. The property where the easement was started changing hands through new owners. And like the newest owners said, you know, that easement, I'm blocking that easement. I don't care about that easement. And I don't have to honor it because the easement was signed way back in 1948 with different owners and we're good. And the fourth DCA said, no, it was an easement appurtenant, which runs with the land, not an easement in gross. So you have to honor the easement. And there's some great language about easements and how to tell the difference between an easement and appurtenant or an easement and gross. And here, even though that the original signing of the easement did not contain both spouses' signatures, that was still not enough to say that the parties did not intend for the easement to run with the land. And another thing about this case stands for the proposition that there's a legal presumption favoring an easement appurtenant that runs with the land, not an easement in gross. Okay, Gabrigi versus Hollywood East. This is Judge Phillips out of Broward. This is an equitable lien case. The party said, you need to dismiss this. There's another case here and estoppel. And the court said, no, you can't go outside the four corners of the complaint to decide something like that. And another thing about equitable liens, it stands for the proposition that the 1-year statute of limitations for equitable liens based on funds does not apply. So the 1-year statute of limitations for equitable liens based on labor, services, or material for the improvement of real property applies, but not based on funds. This is very similar to another case I saw in the first DCA, Newberry Square, Judge Keim out of Alachua County. Same thing where a party said, you need to dismiss this case because there's another action and there's a collateral estoppel issue. And the first DCA said, no, in evaluating a motion to dismiss that alleges an action is barred by a previous adjudication where there is no reference in the complaint to the prior action and no stipulation that the documents from the earlier claim can be considered, the court's analysis is restricted to the allegations of the complaint. So even on an issue of estoppel, it has to be, you have to look at the four corners. Now, does it bar summary judgment? No, and other things, but this is pretty much exactly what Judge Phillips faced, in my opinion, on the motion to dismiss. Here are some injunction cases. Castillo Grand, Judge Singal out of Broward, who's now a U.S. District Court Judge, Cash versus Gagnon, Judge Moon out of Broward, Sabetti versus Smith, Judge Hari out of Broward. Castillo Grand residences, there was a leaky roof in a condominium complex. Water got into the condominium owner's property and caused like toxic black mold. And Judge Singal issued an injunction saying the association shall inspect, repair, and maintain the condominium residence to correct water intrusion and mold problems as pled in the motion. I thought that was very detailed and specific and tied it to the motion. And Judge Singal also didn't issue a bond. The fourth DCA said, no, that's not specific enough. It doesn't describe exactly what the association has to do, and you need specific findings. I'm at a loss for how to get more specific than this because Judge Singal tied it to the motion, but apparently for an injunction, got to be more specific than what happened here. So this is a good roadmap on how to improve upon language in a proposed order to get it upheld on appeal. And then the fourth DCA said also the thing about the bond is not good. An injunction is defective if it does not require the movement to post a bond. And that reminded me of a case in the third DCA I saw, a Pledger Trust case, Judge Thomas out of Miami. And the court held that Judge Thomas, while it upheld other aspects of the injunction, said that the trial court needed to go back down and allow the other side to argue for a bond, because apparently a bond wasn't issued and the other side didn't have the opportunity to present evidence why there needed to be a bond. So takeaway for me is be super specific in your injunction, like more is more, not less is more for an injunction language, and make sure there's a bond in it if you want your injunction to be upheld on appeal. Cash versus Gagnon, this is a stalking injunction case. What's significant to me is the fourth DCA was a little annoyed that people are using injunctions, stalking injunctions, to keep the peace in uncivil neighborhood interactions. That's not what the stalking and anti-stalking statute is all about. We don't just enter injunctions to keep the peace between people who can't get along. And, there was some profanity and lying and defamatory stuff, but that's not enough for a stalking injunction. So don't bring these stalking injunctions based on, you don't like your neighbor. It reminded me of the opposite side of the coin of maybe the kind of case you should be bringing as a nuisance case. This is the Roebuck versus Sills case, Judge Gontarek out of Okaloosa. I'm quoting from the opinion. These people sued their neighbors over a noisy pool pump and annoying exterior lighting. Your pool pump's too loud and your lights are too bright. Nuisance. And the first DCA said, yeah, that's right, nuisance. The trial court crafted the remedy in this case with notable precision. For instance, the final judgment restricts operation of the pool equipment to specific hours each day. It also allows the Silases to run their equipment for the purposes of acid washing, 48-hour period once a year, and time strictures for the exterior lighting. I guess this is the sort of thing Judge Singal should have put in his order. Like, you got to go to clean the roof or patch it up on this day. Anyway, no stalking, use nuisance, or maybe don't sue at all. But those are two injunction. That's an injunction case that was of note in the time period I was talking about. Another case that just came out Wednesday, Sabetti versus Smith, Judge Hari out of Broward. An injunction was reversed, and it was because the court didn't make the required factual findings. So what this tells me is if you win at a hearing and you have a transcript and you submit the proposed order to the judge on the injunction, be very detailed. More is more. Here, they gave Judge Hari an order that wasn't detailed enough, and the Fourth DCA said, no, it's not detailed enough. So put a lot of detail in, cite a lot of evidence, and the Fourth DCA will like that. That's my takeaway from that. We've got about 5 minutes left. I'm going to run through the last set of cases. These are just miscellaneous categories of interesting stuff. The Kavanaugh case, 2 judges were on that one, Judges Shahood and Roby out of St. Lucie. Pride of St. Lucie Lodge, Judge Merman out of St. Lucie. Walker versus State, Judge Marks out of Palm Beach. Bridge Financial, Judge Gillen out of Palm Beach. Kavanaugh versus Stryker Corporation. There was a surgery, and apparently the person's heart was like sucked to the other side of the chest during the thing, and they sued the manufacturer of the device. And the issue was, do we tell the jury to think about what the expectations of the device were to like people on the street, or do we restrict it to the healthcare professional? And the Fourth DCA made it clear that when you have a complex medical product, the relevant expectations are the healthcare professional, not the people at Walmart buying stuff because they don't sell things that can suck your heart to the other side of the chest at Walmart. It may seem obvious, but there was a lot of analysis about it. So that was interesting to me. And then what also happened during the case is after evidence was taken, the trial had started, a juror said, you know what, I can't be here. And I'm quoting from the case, rather than take a weekend recess to accommodate this juror, the trial court granted the plaintiff's motion to excuse the juror and replace him with one of 2 alternate jurors. Instead of seating the first alternate, the trial court gave each party an opportunity to exercise a peremptory strike of that individual from the jury. So peremptory strikes were given out to the parties after the evidence was taken, after the jury was sworn. That is not correct, but the Fourth DCA said harmless error because the plaintiff wanted that, and the striker wasn't messing around. They were just following what the plaintiff wanted. So, but peremptory strikes were given out after trial started. That is significant to me. Pride of St. Lucie Lodge, negligent security case. Person was shot in their car. There was a brawl in the parking lot, and then everybody dispersed, and then one of the people got in their car, and then people came back and shot that person. And the lodge said, hey, we're not liable because in the brawl, that person who got shot in their car like struck a pregnant female, and there's a statute that I want you to tell the jury about that says if you're committing a felony, we're not liable. And the Fourth DCA said, that's not going to work because the person was in their car. They weren't like in the process of hitting the pregnant female. And, to use this defense, it has to be the commission of a felony, or like the attempted commission, not sitting in your car after a brawl. It reminded me of a case out of the 5th DCA, Judge Limanides at Brevard County, DeRosset. The trial court said that this person couldn't have a stand your ground immunity because the room was being used by the niece for prostitution. So yeah, that room, your niece is doing prostitution in the room, and you lose, stand your ground. And the 5th DCA said, no, not sufficient to stop stand your ground. You should have given stand your ground. Okay, we have 2 minutes left. I'm just going to try to run through the next 2 cases pretty quickly. Judge Marks out of Palm Beach, Walker versus State. This was an issue to me that jumped out of the case, was this Daubert issue about whether the detective could testify to the cell phone site mapping technology, placing the defendant in the area of the crime, when the detective himself did not know the algorithm used for the technology. He's like, yeah, I can't tell you how the algorithm works, but I'm an expert on this. And the 4th DCA said, yeah, today much of our technology has a computer-driven component. Each and every computer-driven item has a program and an underlying algorithm guiding the actions of that technology. It would be unrealistic and unworkable to expect every expert who uses a technology with a computer component to be able to testify as to the workings of the algorithm. That's all good. I have a problem understanding the logic of this case because it seems like a significant slippery slope. If you're an expert, in my opinion, got to know what you're talking about. But perhaps it's going to be very costly to have people who know about the algorithm, but still, I have a problem with the case. Anyway, no Daubert issue. The detective doesn't need to know what the algorithm's all about. Last case, we're down to a couple seconds here. I don't want to keep you more than an hour. This is a tortious interference case, Bridge Financial, Judge Gillen out of Palm Beach. There's a doctrine about tortious interference. You can't tortiously interfere with yourself. The question is, if you're a shareholder of a company, does that apply? And if you're a shareholder of significant and insignificant shares, does that apply? And the 4th DCA said, yeah, if you're a 5% shareholder of a company, you can't be liable for tortious interference with the company and its customers, because that's tortious interference with yourself. Whole bunch of other kinds of torts, but don't use tortious interference. And then lastly, in this case, the client list was a trade secret. So that's an hour. And for those of you who are on the chat function, I'm trying to share the demonstrative aid. This was a free 1 credit hour Florida bar approved CLE. This is your reference number. Email me if you need a certificate, I can send it to you, but you don't need that to log into Florida bar. If you want to get credit from another bar, or if you need to tell an employer or something, I'll send you a certificate. This covered 38 out of the 130 plus 4th DCA decisions handed down between September 2nd and December 16th. This CLE was conducted by my company, the Florida DCA Wizard, which I do real-time case law updates, kind of like what you saw, punchy little sound bites with links to the cases so you can look and see whether you want to look at the case and understand more about the case. I'm doing some more CLEs coming up. All the 2nd DCA year in review, the 2nd DCA, December 28th, the entire 4th DCA, December 29th, the 3rd DCA, January 15th. Email me if you have more information, if you want more information about CLEs, and then you can subscribe if you want. You can contact me or go to my website. There's some pricing here, but thank you for joining. I won't keep you more than an hour, and hope something here was helpful to your practice area. Thanks.
Very well done. Really appreciate it.
Oh, thank you. That means a lot. Okay, take care, guys.
Have a